You're listening to Discovery, a podcast presented by the University of Washington School of Law.
Welcome to Discovery. I'm John Blumster, and today we're speaking with Dr. Geoffrey Baird, renowned pathologist and chair of laboratory medicine at UW-Medicine in Seattle. Dr. Baird is a certified expert in anatomic pathology, and clinical chemistry, and he directs the clinical chemistry lab at Harborview Medical Center, and he is no stranger to the courtroom as he has been called in regularly to share insights and expertise as part of some of the biggest cases over the years. Moreover, he's a regular in UW Law classrooms where he helps educate students on how to effectively analyze, interpret, and wield forensic evidence on behalf of clients, which we know can make or break your case. And we're speaking with him today for a primer on how to do just that. So thanks for joining us today.
Thanks for having me.
In a very broad sense, what role do doctors in the medical lab play when it comes to being brought into a case that's coming to trial, just in a very, very broad kind of picture?
So there's two ways I think that doctors in my position get brought in. One is voluntarily and one is not voluntarily. So if there is a mistake or something that has been done in the laboratory, or maybe not a mistake, maybe there's just a clarification or something like a drunk driving case. So I work at our county hospital, Harborview, and many people who do drink and drive and then get into accidents would first come to Harborview, and maybe their first sample that was taken of their blood would be used for clinical purposes and not for legal purposes. And so we may get the first is sort of, I would say, the involuntary part of it would be we may be asked by under subpoena or something like that to testify or to provide documentation about what happened in the clinical lab. We do not use all of the legal methods for collecting specimens or testing them because we're not producing evidence. We're trying to take care of human beings.
Right.
And so you wouldn't necessarily have chain of custody or do other types of tests which aren't clinically useful, maybe legally useful, but not clinically useful. So that would be the first time when we would be asked to testify about something that happened. The second type of engagement that I've had has been through expert witnessing. So when someone would call and ask, would we be able to review outside documentation, something that wasn't done internally? I do actually get a lot of requests to be an expert witness for things like drunk driving or drug driving cases, but unfortunately, those cases oftentimes involve my own laboratory at Harborview because in King County, many of those cases, they do end up in my hospital, and then I'm unable to be an unbiased third-party expert for something that happened in my own laboratory. So it's usually those cases, either expert witnessing or a subpoena or some sort of compelled testimony about what has happened in our laboratory.
One thing I was curious about is when you have to give testimony, like when you had to do that for the first time, was it nerve-wracking? Like what's the process like? As a doctor, you're brought in as an expert. Do you get nervous? Is it nerve-wracking, or do you just come in and just zero in on what you need to do?
The times that I have been an expert witness and been deposed, the first time that happened to me, I told Professor Bailey that it was a bit like a 7-hour colonoscopy. It was just the most exhausting, painful thing where someone was trying to poke holes in everything that I said and question and distort things that I had said, ask about things that I had no idea why they were asking, other than it seemed that they were trying to make me feel like I was at fault or to blame for something, or I was overstepping my bounds, or if I was arrogant, or if I was not actually knowledgeable in something too. And that feeling has continued, I would say, but been blunted as the subsequent times I've done depositions. But the opposing counsel have usually been very, very rough. And in talking with other attorneys, I have understood that is entirely par for the course. That's sort of what normally happens. So I was worried, but I've gotten a lot of good advice, both from the counsels who retained me, also my wife's piece of advice, which was say yes or no and don't say anything else, which was very good advice. My wife didn't do a lot of litigation, but she had some very good advice for me too. So I would say the first time I got deposed, it was very intimidating, and I felt very bad after the day, like physically exhausted, having just sat in a room for several hours. And then the subsequent times, it's gotten less. But it is something that's very daunting, and I think folks that are in my business aren't trained to do this, don't know what to expect for this, and it helps a lot to have someone sort of helping you ahead of time to teach you what to expect.
One of the points that you talk about when you're working with students is it's not necessarily just about being able to talk about the facts, but how to interpret the information that's coming in. Why is this a key distinction to make?
So I think one of the things that I spend the most time harping on, something that in statistics is called Bayes' theorem, but it's also an underpinning of how we do medical decision making. And honestly, it's one of the ways that human beings think. I could give you an example, which is, if you're stuck behind someone in your car and the person has their blinker on constantly, at some point you're going to think that they're probably not turning left. If it's just on for, 10 minutes, they've forgotten it, right? And so you would take all that information, and then when you finally have to make the decision to pass them, you're going to use your sense of reasoning to say, well, are they going to hit me when I try to go around them, or are they not? And you'd use that piece of information before, the fact that it had been on, their blinker had been on for 10 minutes, and you're going to tend to ignore that evidence because you think it's a mistake. However, if someone's been erratic or driving strangely, you would use that and think, well, that actually might be unsafe. Maybe I shouldn't go around if that person's not blinking and they're swerving back and forth. So we use information from before we do tests or before we make decisions to help inform what we do. It's interesting because there's a conflict with the way that the law and evidence works there. So what I've told the law students before is you have to understand what we would call in medicine the pre-test probability. So we do this, say, clinically when someone has all of the risk factors for lung cancer. So they're a smoker and they're elderly and they've been coughing up blood perhaps or something, and they have a nodule on their chest x-ray. We would think, geez, well, now when I go and do a biopsy, I'm expecting cancer. Mm-hmm. And if it's not cancer, you'd think, did we miss the cancer? Mm-hmm. But if it was cancer, you'd think, okay, we figured out what we knew. Likewise, if you had a child who was coughing and you were to notice a little nodule in there and get a biopsy, you would be shocked to see lung cancer. And you would think, well, is there a mistake? Mm-hmm. Did we miss something up? Is it a false positive? Mm-hmm. And so the reason you think those things is because of what you thought before you did the test. So a test is really not a yes or no answer. A test is something that modifies a pretest probability into a post-test probability. And so if something is absolutely unlikely or impossible to be true, and then you get a test that says it's true, you should really think about that. The example I use in the class often is, what if you were to administer a pregnancy test to me? If it was positive, you'd think, he's probably not positive. You don't know. Yeah. It might be, my physical appearance might be even misleading, but you don't know for sure, but you'd think it's really, really unlikely. That's because before the test, you were thinking, this person is phenotypically, they outwardly appear to be male, probably not able to carry a pregnancy. And so the pregnancy test, you go from maybe 1 in a million chance from being pregnant to, if it's positive, somewhat more likely, but still, maybe 50 in a million or something, like a very unlikely chance. Likewise, if there's a woman who has a big belly and you can see the baby kicking inside and you do a pregnancy test and it's negative, you would think, well, that's something wrong with the test, right? So patient's pregnant. If they're obviously pregnant, they told you they're pregnant, they look pregnant. You do an ultrasound, they are pregnant. Something went wrong with the test. So you discount it that way. The alternate answers, though, are even more interesting, which is if you get a pregnancy test on me and it's negative, or a pregnancy test on the person who's pregnant and positive, you knew that beforehand. Why did you do the stupid test? So on both ends, you tend to want to do tests at a time when you don't necessarily know the answer, but you definitely use the information you had before. Now, the thing that's been difficult to relate from my time from the grand jury and also in talking with other legal experts is the way that evidence works is you can't necessarily pull in a bunch of unrelated evidence in a case. So just because someone has 17 convictions for meth use and the time or meth trafficking or meth possession, and now you have, this patient was caught with a white powder and they did a test on that white powder and it was presumptively positive for methamphetamine, you're not likely to say, well, that's a meth person, the meth dealer, and they've been convicted. I'm going to use that to help me do that, even though that is the logically and sort of clinically useful way of thinking. And that's actually the way that human beings think all the time with that driving example I gave. So that's why I think it's important to talk about the interpretation of test rather than just simply the fact of the test or the answer of the test. Because even though you're not maybe allowed to use that approach in court, you need to think about that when you're weighing the evidence that you have in any particular case. You need to understand that, well, here are the things that were pre-test issues that were going on. And so I'm going to think about this positive or negative result in that context. So if it really does sound like that was a false positive test, that person had a lot of good reasons not to have been doing that drug or have that result, then you would need to go back and really think about scrutinizing it, maybe get an expert to say, what are the possible reasons this could be false? Whereas if everything lines up and the person admits it, maybe you don't want to try to, it's going to be futile to do that.
Where do you see pain points or the steepest learning curve when it comes to really being able to master, the kind of concepts that you're going over when it comes to medical evidence?
I think that there's maybe sort of more global and and some specific issues. The global ones is that I think that there is illiteracy is a hard word to use. I would say an underappreciation perhaps of general sort of scientific sort of thought processes and basic sets of facts, like, how in say in medical malpractice, how medicine, physiology, and chemistry actually work. That's left oftentimes as this black box. And I get this impression that if there's a case that involves some sort of medical, scientific, or biomedical scientific fact at its core, generally the idea is that there's going to be a fight and that whoever gets the smartest or most expensive expert to, bend the fact or the interpretation of the fact wins, when in fact, the actual core truth of it is something that, everyone involved could appreciate, but that's usually the thinking is oftentimes deferred to the expert rather than, perhaps taken as the duty of the lawyers involved to really understand those things. And I've seen as a layperson, there are attorneys out there who make it onto the news who have, made themselves names as being experts in DNA evidence and such like that. So it is possible to do that. But I think a lot of times the science is this thing that sort of they draw a box around it, put it in a corner, and that's just something that, it's another chess piece in this whole thing. Whereas for me, it's the actual underlying ground truth of what occurred. And maybe I'm naive to think that there's the underlying ground truth should be the thing that dictates what happens. It isn't always, I understand. I think in specific cases, though, one of the things I've told medical students and residents too is that medical education is a long process of disabusing yourself of believing all these things that seem so obviously true, but actually aren't. Like it seems that, when it's cold outside, and you have wet hair or something like that, you get a cold, right? And you shouldn't go outside when it's cold, you should bundle up. It turns out that, flu viruses and cold viruses circulate in the winter for a variety of different reasons. So it is cold when you get the flu, but it's not the reason you get the flu. And so, the germ theory of disease takes a while, to understand how that actually operates. Now, there's a lot of other things like that, things that make sense. There's also a lot of misinformation on the internet, or I wouldn't even say misinformation, but sort of half information. One of the common things you can do is you could Google what is a source of a false positive for my meth test. And what you'll get is thousands and thousands of hits of people who have both reported it. There'll be scientific literature on it. There'll be drug enthusiast websites, things where people like doing drugs and post tips and tricks on how to evade things. There's an enormous amount of half information on that. And one of the idiosyncratic things about drug tests is there may in fact be a certain type of test that has a false positive or a false negative that's known, but it doesn't go to the second type of one. So you really have to know exactly what happened, exactly what test, what form of the test, if it was sold by a vendor, what vendor created that test, what generation of the assay was it, all those things to know exactly what that specific test's problems are. There was I think a lotion, like a moisturizer that had caused some false positive THC tests, so cannabinoid or marijuana tests. And I think this was reported on the East Coast somewhere. All of a sudden, people are saying, well, I've been, using moisturizer that clearly exonerates me from, my THC test. And the answer is no. There was one specific type of screening test that had that problem. We don't actually use that screening test here in our system, so it was completely irrelevant. But you have to understand that there's different ways of doing these things. And so I think that there's a lot of misinformation out there or half information, which sounds really great, but once you sort of cut through it, there's not much underneath it. So I think disabusing folks of things that they believe to be true because we've all thought that.
That's so interesting. So it's not just the test result, the yes or no, but the concept, the parameters, and all of that is just as important and consequential. And so when you're working with students and telling people this, do you see any pushback in terms of, well, then how are we, if this test, the parameters are too low, this one's too high, like how are we supposed to use any of this, in terms of court of evidence, right?
The students do frequently ask a lot of questions in exactly the way that you're sort of framing it about what to do with this information if it is then confusing. And I think that you can strike a happy medium and find where, this result seems as plausible. Now, with something, maybe I'll reflect it back to the legal world here, is I don't actually understand what words like probable cause mean, in terms of using a lab test. When someone comes to Harborview and's crashed their car and they need to find out if they have, a medication on board that's causing a heart arrhythmia or something like that, I don't try to meet a standard of probable cause or a majority of a preponderance of the evidence or beyond reasonable doubt. I tell them, that they have that medication on board, or I tell them that it's negative. And we try to figure out what the actual truth is and we act upon it. It was very frustrating when I was a grand juror. I actually reached out to faculty in the law school here before I started, when I was selected for grand jury, and I asked someone, could you please send me information about what probable cause means? And I read a lot about it, and what I have to say is it's not entirely clear to me that probable cause has much to do with either probability or causality. It wasn't 51%, chances, because oftentimes in medicine, we can actually give you those answers. If we can quantify, which we frequently can, pretest probability, I can tell you how likely the test is to give a false positive or negative, because we quantify that. We actually assign numbers to that. We can actually make risk calculators that say, yeah, you are 51% likely to have taken that drug, or 68% likely, or only 1% likely. We can actually assign those numbers, but then the legal system may not actually care about that number. It may be very important that probable doesn't mean 51%.
I guess I'd like to kind of tie it all together with an example of a case that you've been involved in that we talked about before. One of the cases you talked about was a drug to driving case, which had to do with someone who it was in question whether they had done methamphetamine or not. Could you tell us a little bit about that case and how that played out, your role, and
Sure.
kind of that trial, your experience?
Sure. So as the head of a toxicology laboratory at the county hospital, I get a lot of calls from folks who want to know about drug testing and specifically drug driving. And in one case that I remember that I've seen, the question was whether or not someone had been using methamphetamine during a car accident. And I believe it involved a company, that there was it was a corporate truck or something like that hit a passenger car or something like that. And someone wanted to know if there was a positive result. And when the person went for medical care, and not into my own hospital, they had a routine urine drug screen, which is one of these more non-specific tests that looks at drug classes. And it was positive for methamphetamine or amphetamine, one of the two. Now, those are very closely related drugs, and so it's sometimes hard to tell them apart on a screen. And so the question here was whether or not this supported that the person had actually used methamphetamine when they were driving. And the opinion that I gave, which is, I think, a standard opinion that many, those in the toxicology world would give, is that actually methamphetamine screening tests are among the most unreliable tests that we do in the clinical laboratory, largely because there's a lot of drugs that we give that are structurally very similar. So things like Sudafed and over-the-counters, and a large number of drugs of abuse too. But there's a lot of things that have the similar molecular shape. And the screening tests we do all respond to the shape of the molecule, not necessarily some other property of it. And so if there's similarly shaped things, they will respond. So methamphetamine and amphetamine and maybe ephedrine, may on some tests do react. Some tests may be more or less specific to some of those things too. Same thing with opiates. So oftentimes a screening test can't tell the difference between hydrocodone, which is Vicodin, or morphine, or codeine, or Dilaudid, which is hydromorphone. It's just one of those ones is there, or a mixture of them are there. We can't really tell. And so what I said was, no, with a screening test, that isn't good evidence of it. It's more likely for sure if you took 100 people who had positive screen tests and 100 people who have negative screen tests, there's going to be more methamphetamine users in those 100 people who had the positive test, but it's really a statistical enrichment. It's not definitive. What we then do clinically, if we need to make the distinction, and then again, legally, you would always have to make this distinction, is we do a confirmatory test, which then measures methamphetamine itself by a different method. And this patient had not had that done, patient who was also, I guess, a defendant in this case, had not had that done. And so there wasn't enough evidence in that case to do that. And so this is also a question where I had to, as I referred to earlier, try to figure out what was the actual screening test that was done. Sometimes there are some versions of screening tests that are actually quite a bit better in determining that, and some that are really awful. So the type that you would maybe buy at the drugstore, you pee on the little strip and you get a stripe or not, sort of looks like a pregnancy test. Those are pretty bad. Whereas if it was done in a big instrument in a big crime lab, generally you might think that that was a better test. And so I had some questions about that, but in general, a screening test, especially for methamphetamine, should not be seen as evidence of use. The other important thing that I try to teach too is that urine screening usually can only tell you if the patient has been exposed to the drug, meaning that they either ate it or it got into them somehow, but it doesn't tell you if they were intoxicated or impaired. The reason for that is the level isn't very important. What's important for impairment is your brain level of something. How much methamphetamine or cannabinoid or morphine or heroin or whatever got into your brain. The amount that's in your urine is sort of the average amount that you've metabolized over time divided by the amount of water you drink. And so if you drink a lot of water, your level will be pretty low. And if you don't drink much water, your level could be pretty high. And it could be wildly higher or wildly lower. And it doesn't really reflect what was going on. So if you want to figure out what someone's brain level is, the analytically perfect thing, which would be totally unacceptable, would be to take a piece of brain and measure it in that, but we can't do that.
No, it makes sense.
So exactly. But what we do is we measure blood levels. And if we measure in the blood is close to the brain level in many cases. And so we usually have more evidence scientifically that the blood level tells you. That's why we do blood alcohol testing. And that's also right now in the state of Washington why we do blood THC testing. And so the blood level correlates better. I will mention interesting about the THC level. The THC level is something that was also sort of picked out of a hat. So the drug driving level for THC is 5 nanograms per mil of whole blood. Whole blood isn't normally what you would test for THC in. You would test it in serum, which is it's a pedantic point. I think the reason it was done in whole blood is that's what we do alcohol testing in, and the cops will have that sample. But the 5 is actually neither very sensitive nor specific. So there are people who use a lot of marijuana, medical marijuana users, or just the types of people who use marijuana all day, get up in the morning and use it till the end of the day. They can become somewhat tolerant, and a level of 5 might be what they wake up with in the morning. And maybe they can drive at that. Maybe not, but maybe they could drive. Then, for people who are more naive to it, 5 is quite a bit, but there are also active metabolites that they don't measure. So you could have 4 of THC, 4 nanograms per mil of THC, and then a little bit of the active metabolite, and you would be impaired. But we would say that you were not above the level. So you can both, again, falsely maybe accuse someone of being impaired or miss someone who's impaired with that level. Again, as a matter of convenience, we have to say that there's a level that you're above which you're positive and below which you're negative, but that causes confusion and some errors that we know about.
It's been so fascinating to hear your perspective and how we analyze these tests, and I know that law students are going to take a lot away from this. And so again, we really appreciate you sharing so much because this is really, really interesting topic. I guess for law students who, maybe want to be litigators but maybe are a little bit more wary about how to handle medical evidence and just talking about these extremely complicated concepts in general, what advice do you give, to encourage people who may be a little bit unsure about how good they're going to be at handling this kind of evidence?
That's an interesting question. I'd have to say that one of the pieces of advice I got in my own profession from my father. I went into my dad's profession. He was also a clinical pathologist, and someone that he trained from told him this, which was that no one gets any good at this until you're about 50. And so I'm not yet 50, so I think I still have some time to get good at it. But I think that the point of that is that there's an enormous amount of lifelong learning that has to go into the law as well as medicine too. And I would think that if someone wanted to be a litigator in cases that were going to involve, say, medical malpractice or drug tests, from liability cases, or I don't know what other, it would do them well to actually participate actively in continuing education specifically targeted at this, and actually to have some sense of the actual means of what's going on. The best attorneys that I've talked to are the ones for whom I could spend, a day, and I've done this before too, as part of an expert witness thing, is spent simply a day with the legal team going over basic chemistry and biology on how these things work. And those who come and me just like want a quick answer and just want me to write something down and say yes or no, or want me to look through a bunch of paperwork to try to find, the needle in a haystack error that got made, those aren't the sophisticated ones. But the ones who are willing to sit down and actually say, we need to be educated for hours about, how does this type of blood testing work? How does this work? I think that's a great sign. And I think that it's inescapable that to be good at this, I think you actually will need to get some domain knowledge. Now, you don't need to be an expert in this. That's why experts exist. And that's why you have the ability to hire them. But I think you can't treat it as in vacuo. So I think the first step is to understand that you maybe aren't an expert in everything, but you need to get some level of expertise. I think in medical education oftentimes is the first thing you need to do to learn medicine is to learn what you don't know. And the second, that's the first way that we sort of trust people in medicine is when we're really sure that someone knows what they don't know. Then we can have them, pick up a phone and answer a question because they'll always know, well, I don't know that. I'll go ask someone. And so the first thing you need to know is like what you don't know. Oftentimes we go as an attorney too. I think operating when you don't know that you don't know something, that's the most dangerous because then you would go forward with a misconception. And so I think getting to the point where you, at the very least, where you know what you don't know about things, or for example, like there's a bunch of different types of tests. I do know that the tests will act differently and have different sources of false positives and false negatives. I need to get an expert to tell me which test was done here and is that test the one that has this false positive or negative? But if you don't know to ask that question, then you'll never get there. So I think that the level that one needs to get to and as an attorney is to get good at knowing when the expert is needed and when not. The idea that an expert's needed for everything is a waste of money, honestly. It's not helpful for me to go look through a bunch of pieces of paper, even though sometimes I've done that. Looking for the needle in the haystack or the typo in something that calls the whole thing into a question. That's not usually likely at a crime lab to have occurred. But never calling one too, or not calling one when you should is another thing. So I think that's the sort of the fundamental level, I think, of education that someone should get to then get over that worry of not really knowing much about this.
Dr. Geoffrey Baird is Chair of Laboratory Medicine at UW Medicine in Seattle and a regular guest at the UW School of Law. He often serves as a guest lecturer and works with students to help them become more effective at wielding medical and scientific evidence in the courtroom in order to advocate more effectively for clients. You can learn more about his work on our podcast page at law.uw.edu. Check out the show notes for links to more information on all the topics we discussed today. Thank you, Dr. Baird. This has been super fun. Thank you very much.
Thank you very much for having me.
Discovery is hosted by John Blumster and produced by Greg Olson. Additional voiceover work by Ben Gonio, with original music by John Blumster. Discovery is recorded in William H. Gates Hall at the University of Washington School of Law in Seattle with the support of Mario L. Barnes, the Tony Rempe Dean. For more, visit law.uw.edu.